and welcome to the channel. On behalf of Indian City Council Academy, I welcome you all to the series of important maxims in the legal field. So, welcome students. Today we're going to discuss about the very important legal maxims and their very easy meanings. Starting from the ab initio, we will be going in the alphabetically order from A to Z. And in this series, we're gonna discuss about all the possible legal easy maxims, starting with ab initio, which means from the very beginning. That is, if something is, if something, a case or something, a proper example can be given of this is that when a person files a case, the cause of the event or the situation which caused the event to cause, we gonna hear it from the very beginning, right? The inquiry occurs from, which means from the very starting, like from the root cause which caused an event. Actionable per se, that is, a very act is punishable and no proof of damage is required. For example, when an act is itself stating the punishable, like it's punishable, okay, and no proof of damage is required. For example, if you murder somebody, in case of murder, you know what's the punishment is given, right? So there is a damage caused, and there is no proof required for the damage to so cause it. The next point is actionable action. Action, personalist, monitor, cum personam. A personal right of action dies with the person. In other sense, if he dies, the right to sue is gone. For example, if a person, you had an accident with a person, okay, and after, before you file a case, the person deceased or dies due to some incidences, then the right to sue of yours ends up there. Then, actuary incumbent onus probandi. The burden of proof is on the plaintiff. As we all know, who is the plaintiff? A plaintiff is the person who files the claim, like the person who instigates the case. So it's always on the burden on the plaintiff to show cause to the court that a damage or some nuisance or maybe like anything and which is caused to the person due to which the person has come to the approach the court for such issue. So moving to the fifth one, we have actus me in vitro, practice non est mens actus. That is, an act done by me against my will is not my act. Reading with section 94 of the IPC. So, when an act is done by a person against his will, it is not considered his act. So, what does section 94 of the IPC states? Section 94 of the Act states that to which a person is compelled by threats. If a person is compelled by threats, at that point of time, the act is not considered his because he is under a pressure to give a statement or do an act. Moving next, we have the actus non facit reum nisi mensit re. An act does not make one guilty unless it is accompanied by a guilty mind. As we all know that it is a necessary condition to commit the act, essential condition of an act that it should have a guilty mind. And actus reus, a guilty act. That is, A guilty act should commit a guilty said that a guilty act committed by the person with a guilty mind. So moving next, we have here the actus reus non facit rem nisi mensitria, that is, conviction of a crime requires proof of a criminal act and intent, or an act does not make a defendant guilty without a guilty mind, or an act does not constitute guilt unless done with a guilty intention. In simple words, we can say this that a conviction of a crime requires a proof of a criminal act or an intention. To convict a person, the two conditions must be checked before punishing the person, that is, the guilty mind and the guilty act. Until these two conditions are fulfilled, a person cannot be convicted, right? Okay. Going forward to the ninth, we have ad hoc. That is, what do you mean by ad hoc? For the particular end or the case at hand. So it basically talks about the case or the particular end, which is as. Next we have LB, at another place or elsewhere. Moving next, we have amicus curiae, a friend of court or a member of the bar who is appointed to assist the court. This is legal terminology used. Moving next, we have here, out here we have ante litem mortem, that is, before suit brought, before controversy instituted, or spoken before a lawsuit is brought. It can be considered as an informal talk before a lawsuit is brought into the court of law. Next we have assento mentium, the meeting of minds, that is the mutual assents. It is generally heard in the cases of divorces, where there is a mutual assent or mutual understanding between the parties to get divorced. Next we have Audi Altrum part, the most heard maxim in the legal knowledge. That is, no man shall be condemned unheard. That is, no man should be left unheard before he is condemned. Next we have bona fide. Bona fide, we all know, it's a very easy one. It says that in a good faith, that you should be bona fide. It should be in a good faith. We have next bona vacantia, that is good without a known. Next we have boni judicis as impellere jurisdictionem, that is, it is the part of a good judge to enlarge his jurisdiction, that is remedial authority. When a case is held beyond his jurisdiction, it is the responsibility of the court to provide a remedial authority, a pardon remedy to the person. Moving to the 23rd, we have communis hostis hominum, that is, they are common enemies of all. The common enemy of everyone, which is read to be read with the section 4, clause 2 of IPC. So section 4, clause 2 states that any person or any ship or aircraft registered in India wherever it may be, that is, a person wherever it may be, are the common enemies. If it is given, corpus out here means the body. So next we have here caveat, a caution registered with the public court to indicate to the officials that they are not to act in the matter mentioned in the caveat without giving first order to the caveator. So, what is the meaning of the caveator? Caveat is a Latin phrase which generally means that let the person be aware. In a formal notice, when the person is always intimated before any legal action are taken against him or her. So, next we have caveat actor. Let the doer be aware. Out here, in the first case, we're talking about the person who was to be aware, and here we are talking about the doer be aware. And same we have caveat emptor, that is basically found in the Consumer Protection Act. Let the buyer be aware. And caveat venditor, that is let the seller be aware. Next we have, so now we have certiorari, that is a type of a writ, that is, as explained here, a writ by which order is passed by an inferior court is forced. When, for example, it can be given when a subordinate court gives an order and it is quashed by the superior court, then it is basically a certiorari. Going forward, we have here the 25th and the 26th serial number, that is corpus dulcet, the fact and the circumstances constituting a crime or concrete evidence of a crime, such as a corpse or that is a dead body. Also, it refers to the principle that a crime must be proved to have occurred before a person can be convicted of committing the crime. The definition is mostly used in the Western law. That is, if we talk about the explanation, the fact and the circumstances constituting a crime or a concrete evidence of a crime. That to constitute a crime, there should be, when you're convicted, the facts and based on the facts and the circumstances, and there should be have a concrete evidence against you to get convicted. Next, we have crime trahit personam, that is, a crime carries the person rated with Section 2 of IPC. In other words, it means wherever a person goes and if he commits a crime there, then he will be covered by the provisions of the Indian Penal Code, that is, interterritorial jurisdiction. Next, we have here the most commonly used maxims, that is damnum sine injuria, that is damages without injury. Next we have de facto, which says that in fact, de jure by law, de minimis about the minimal things. Then we have de minimis non cuitre, like the law does not govern trivial or unimportant things, or law is not connected with the small or insignificant thing matters, which is to be read with Section 95 of the IPC, a common law principle whereby judges will not sit in the judgment of extreme minor transgressions, offense, wrongdoings of law. Next we have here is 32. De novo, to make something anew. Decitum, statement of law made by the judge in the course of decision, but not necessary to the decision itself. Dole capax, capable of forming necessary intent to commit a crime, which is to be read with section 83 of the IPC. Dole incapax, which is the opposite of the dole capax, which is that incapable of crime or incapacity of forming an intent to commit a crime. which is yet to be section 82 of the IPC, detainee thought of wrongfully holding goods that belongs to somebody else, donatio mossis causae, gift because of that, or a future gift which given in exception of the donor in upon death and only delivered upon the donor's death. That is, the best example could be of this is when you are mm, when property. The best example of this would be property. That is upon death, when the property is transferred to the another person, to the owner. For example, after the father dies, the property is transferred to the to its son, and that doesn't happen before until there is a will or agreement stated by the father. Next, we have estoppel. Estoppel, you can remember it from the very word stop. That is, out here we have the stop. The estoppel means from preventing, from denying, and ex gratia as a favor, ex officio because of office held, ex parte proceedings in the absence of the other party, and the ex post facto out of the aftermath of the aftermath or after the fact. So with this today we come to the end of our series of the first section. This is our first video. To I request everybody to show the support and also thank the viewers. And do you find this necessary, or if you find anything which is lacking in this, do comment and let us know. Thank you.